Okay, very good. Welcome, everybody. My name is Marty Mascari. I'm with the North Central Texas Area Agency on Aging. Welcome to the webinar. Once again, we're partnering with Haiman+Hogue to offer another incredible webinar for you all today. If you'll go to the next slide, I'm going to first start with asking Sheila to talk about CEUs for those of you that are looking for continuing education credits.
I am not getting this to go forward.
Sure, because
you're at the back.
That's at the end.
You're at the end. You got to go all the way back to the beginning. There you go.
I know, because the registrants must have think, what? That's not what I signed up for.
Okay. Sorry about that.
Sheila, it's all yours.
Okay. Well, good morning, everyone. We are pleased to do these CEUs for you, and it is very easy to get your credit for them. And you will get 1.5 hours credit for this one, by the way. When at the end of the CEU, and when Marty sends out the follow-up, you will get a sign-in form. You will get the slides. Yes, you will get your own personal copy of the slides, which is wonderful so that you can have those to refer to. You will get 2 things from us, though. You will get a sign-in sheet and an eval form. Okay, in the eval, obviously, you're used to doing those to get credit. Tell us what we're doing right or wrong, or what you learned or what you didn't learn. And the sign-in sheet is just to let us know who you are and what you do. And then there is this says mediation conflict of interest, but it isn't. Anyway, but there is but that's okay. That's okay. I'm going to dispel that right now. Take care of that right now. We are, if you've not been on one of these with us, we are Haiman+Hogue. We are an elder law firm. So we do this for a living. So, but our intent today is purely to educate you. So that, and I always say in the follow-up, please use us as a resource so that we can help you do your job to help others, because we're faith-based, and that's how we're founded. That's our mission. So please help us to do that. And so as soon as you send me the sign-in sheet and the eval, I then will turn around and send you your certificate. But in no way, shape, or form is this an advertisement for our agency. It is purely an education. There will be plenty of time for you to ask questions at the end, and we have a double whammy today, because we have Rex Hogue, who is a founding partner of the firm, and then we also have Jeff, who is our attorney who was on last month, if you were on last month with the mediation, our senior attorney that does Medicaid. He also does VA, and he also does guardianship. So any family fight type situations usually go to Jeff. So anyway, he's involved in this and will be Rex's wingman to answer a lot of questions. So between the 2 of them, they'll get all your questions answered, I promise you. So
thank you, Sheila. So what you might find out is if you have a blended family, you might need mediation conflict. So that's really why I left it there.
Oh, okay. That's fine.
Sorry. Well, Rex, we're going to turn it over to you. Thank you so much, and we look forward to it.
Great. Well, thank y'all. I'm Rex Hogue, and today we are going to talk about America's favorite blended family, the Brady Bunch. Now, just so you know, we have compiled facts from the show. We've compiled facts from later special movies, and we've added assets that we find are typical of blended families. And then we've added situations that don't conflict with the facts, with one exception. We've moved the Brady Bunch to Texas. And we have samples of situations that any family might run into. We just want you to know we didn't completely make all this up. At the start of our presentation, we're going to go right about the middle of the show. Mike Brady is 44, Carol is 43. They've been married for 3 years. We have added that they have a prenuptial agreement that will come into play later. Mike has 3 kids. Greg is 17, Peter is 14, Bobby is 11. Carol's kids, who actually wasn't Brady, Marcia Martin, Jan Martin, and Cindy Martin, are 15, 12, and 9. And then, of course, we all remember Alice. Mike married right after college. He took a job as an architect with the Phillips firm in Plano, Texas. He became a junior partner, about a 10% interest, 6 years ago. His first wife died 5 years ago, and it was after that that he met Carol. His grandfather was a judge, Judge Brady, and we have added that Judge Brady lived on a 3,000-acre ranch, and it included oil and gas royalties. His father was a retired petroleum engineer, and so that we would have a name to work with, we have referred to him and his wife as Paul and Grammy Brady. He has a lot of oil company stock when he retired because he did work for an oil company. And after Judge Brady died, he kept 40 acres. That's where he and Grammy live. And they have a few cows, some horses, and chickens. It's mostly a little mini ranch that is more of a hobby to give them something to do. When he sold the ranch, he put half the sale proceeds into more minerals and half into oil company stock. They love having the kids come out, and they have absolutely fallen in love with Carol's girls. So every summer, they have each set of kids for a week. They have the girls for a week, and they have the boys for a week, and they just have a lot of fun out on the ranch. Mike intends to keep that ranch after he inherits it, perhaps as a family vacation home and vacation spot. Carol grew up in Massachusetts. She married and moved to Texas. She was divorced 6 years ago. She and her husband have joint custody, but he lives out of state. He sees the girls once a year. He does have monthly communication, but he doesn't play a big part in their lives. She feels like the lack of planning cost her a lot in her divorce, and I've talked to a lot of divorced people who feel that way. She wants to keep the separate property separate, and that's not at all unusual for someone coming out of a divorce and heading into a marriage with someone else with kids. She has a brother named Jack. He and his wife live in Austin. If you watch the show, you may remember Cousin Oliver. He is the parent of Cousin Oliver, who isn't going to play a role today other than being mentioned here. Carol and Jack were pretty close growing up, and they've been close until something happened. Now, shortly after Mike and Carol returned from their honeymoon, Carol's parents were in a very bad car accident. Her father was killed. Her mother, Connie, was left with brain damage, but she recovered physically. Their parents had no estate planning in place, and that proved to be a nightmare. And I'm going to just not go into great detail, but talk about some of the things that they went through. First, they had to do a probate for her dad. He lived in Massachusetts, so they had to do the Massachusetts probate, but they also had property in Colorado and Texas, so they had to do ancillary probate in both of those states. As if that wasn't enough going to court, they had to do a guardianship for Connie in Massachusetts, and then get permission to move that guardianship to Texas, since neither of the kids lived there, and Connie didn't have anybody to take care of her in Massachusetts. She now lives in an assisted care facility in Austin. Frankly, Jack had more time and fewer kids to deal with than Carol did. So that has created some tension between Jack and Carol. And we find frequently when a parent is in a facility that kids don't agree on how things are going to be done. Jack thinks she should be put in a memory care, but Carol thinks Jack and Pauline just don't want to deal with mom. She's not happy about it. But then she got a call from Jack. Carol was thinking she wanted to move her mother up here. A lot of times every kid seems to think they can take care of mom or dad better than the kid who's doing it. That's very common. Well, Jack called her and told her she could expect a call from the FBI. He went over to visit Connie, and Connie told him that she had heard German voices in the attic. She was convinced that where she was living was crawling with German spies. obviously going back to the early days of her life, worried about World War II, and she wanted Jack to call the FBI, so he agreed to do it. She also was concerned that her roommate was one of the spies. Well, Jack went back the next day and he said, "Mom, you're right. This place is crawling with German spies. The FBI knows it, but the first thing I need to tell you is your roommate is not one of them. But the FBI does have a plan. They have the staff speaking Spanish to confuse the Germans." Connie thought that was a brilliant plan, and she was satisfied. Of course, Jack was kidding. He didn't really call the FBI, but they thought, okay, we fixed that problem. A few days later, Jack got another call from the facility. Her mother had watched a crime show, and she thought one of the elderly residents was a criminal from a crime show, and she started hitting him with a cane. And at that point, they realized they had to move Connie into a better facility, and the facility told them, you either move her to memory care or you come pick her up and take her somewhere else. So they made the decision to go ahead and put her in memory care. And at that point, Carol realized that things were more difficult with her mother than she expected. Now for assets, Mike and Carol have a joint home. They have checking and savings, household goods. Mike has a 401k. They have 2 cars, and they have life insurance on each of them. And they did what we find a lot of people do in a situation like this. The beneficiaries of the life insurance are the spouse and then each spouse's own kids. A disastrous plan, as you will see. Then for Mike's separate property, he has an IRA that he no longer contributes to. When they got married, their lawyers advised him to stop contributing to that IRA. Then his interest in the Phillips firm, and that is his separate property under Texas inception of title rule. I won't really spend any time talking about that rule, but it's important to know that. Carol has an IRA that she no longer contributes to. Then in their prenuptial agreement, the attorneys advised them to stop contributing to the existing IRAs and create new ones and make those IRAs separate property. So they did that in that agreement. Now we cannot opine on whether a marital property agreement is valid, but we can assume that since they each had separate attorneys and it appears to meet the requirements, that it is. Now, they currently have no estate planning, so we go through with them, what if? What if one became incapacitated? Well, they found out that would mean a guardianship. They've already been through a guardianship with Connie's mother. That experience completely satisfied them. They see no reason to ever be involved in another guardianship. They found out on the death of either, there would be a probate. The home would be owned half with the surviving spouse and half with the decedent's kids. Trust me, that is not something that's very attractive, especially when those kids are minors. That home will be under a guardianship for the kids for years to come, regardless of who dies first. Life insurance, the kids' share, is going to be under a guardianship for years. But the good news is when those kids turn 18, they're going to get that share. That is just not a very good plan. They found out that half the community property goes to the surviving spouse and half goes to the decedent's kids. Now the survivor doesn't owe the decedent's kids anything past age 18. They also found out that 1/3 of the separate property would go to the surviving spouse. Mike and Carol do not like that plan. Now, if you don't have a plan and you leave your family in a mess like no planning would leave them, we do have a number that you can give your family to call. 1-800-YOU-BLEW-IT. Because if you don't have a plan, that's going to be a nightmare for your family, especially with blended families. Then there are some dragons that they deal with, and at this point I'm kind of explaining to you a little bit about Texas rules. There's what we call the administrative dragons: power of attorney failures, guardianship, and probate, and then medical documents. That's one of those cute little dragons there. The hardest part about this presentation, by the way, was going out and getting pictures of live dragons. Then there's the tax dragons: capital gains, gift, estate, generation skipping, transfer tax, business entity taxes. We're not going to really talk about taxes today beyond acknowledging that that is something that Mike and Carol need to consider. That's a big, scary, fire-breathing dragon that nobody likes the IRS. Then there are predator and creditor claims. And there's two aspects to this. First, protecting yourself. We're not going to deal with that with Mike and Carol today. We could certainly do that, but we are going to talk about protecting what they leave others. And that's a dragon that just seems to come flying out of nowhere. People have no idea, and suddenly they're sued, and they think, man, that just came out of nowhere. Lawsuits don't come out of nowhere, folks. If you know what to look for, it's not that hard to spot the potential. Now, we're first going to deal with our administrative dragon. We're going to start with 6 key medical documents that we prepare in our office. The first is a Hipaa patient authorization that simply authorizes someone to get medical information. Without that, medical facilities cannot share medical information about someone. Then there's the durable special medical power of attorney. That allows someone else to make decisions. These two documents work together because it's pretty bad if you're told you can make a decision, but we can't tell you anything about the patient. So you've got to decide without information. We have a document we use in our office called the Personal and Healthcare Instructions, and that's an opportunity for clients to tell their family, this is what I would want under these certain situations. We also have a directive to physicians, also known as a living will. That allows the doctors to pull the plug. Without that, you can wind up in a Terry Schiavo situation. Actually, that's a very poor example for this, but nobody wants to be on life support for an extended period of time. An anatomical gift form gives them a chance to choose whether they want to give anatomical gifts, and also in Texas, express their opinion about doing an autopsy that's not required by law. Then there's the disposition of remains form. Another thing that we think is worth talking about is a company called DocuBank that will keep these documents on file. They can fax them or email them to any hospital in the world 24/7. Then there are powers of attorney. We're now dealing with the legal side of incapacity. Powers of attorney don't work the way a lot of people think they do. And a principal gives an agent a power of attorney, and it's really an invitation to third parties to let that agent act on their behalf. Now, like any other invitation, third parties have the option of accepting it or rejecting it. Unfortunately, they are rejected way too often. I've been doing this for 28 years. I just find that there's a lot of cases where powers of attorney don't work. They certainly don't work the way people think they will. Then there's a guardianship that may be called a conservatorship in some states. We define that as the court-supervised management of assets for somebody who is legally incompetent. Some people call that living probate. Again, this is a difficult scenario. The third way to deal with incapacity is through a living trust. It can replace powers of attorney. It can provide the necessary substitute signature so that you don't have to go to the court for guardianship. It avoids guardianship and probate. It can even provide instructions for the incapacitated person's care. Guardianship and probate are caused by the exact same problem. And that problem is we need the person's signature to either manage assets or transfer assets. Incapacitated people do not have the capacity to sign documents, and dead people don't sign documents. I don't know how they vote in some places, but apparently that's possible. However, in this area, they can't work without their signature. Guardianship and probate solve that problem by going to court and having a judge authorize a substitute signature. They are and frequently the only solution to the problem. But if they're the only solution to the problem, it's either because other planning failed or they didn't have the appropriate planning for their situation. They are not the best solutions to the problem. Now, guardianship, I tell people it's one of those 12-step programs. Nobody wants to be in a 12-step program. There are 12 distinct steps to guardianship. The minimum cost is typically between $9,500 and $30,000 or more initially. I've even seen a case where it was $82,000 to get a guardianship just in place. Then annually, you're going to spend another $2,500 or so, but maybe more. And it seems like a constant stream of surprises. It goes on for as long as the ward is alive. It's disastrous for otherwise good estate, business, and asset protection planning.
Hey, Rex, can I jump in here real quick?
Yes, absolutely.
So one of the things that Sheila mentioned that I do here at the firm is to handle guardianship matters. And I just want to highlight this issue because Rex raises a very important one. You know, it's fine in guardianship. It can be relatively straightforward, but it can be very not straightforward. If you have family conflict, kind of like the last webinar that we talked about that, I just recently was involved in a guardianship where collectively the parties spent almost $500,000 just to get a guardianship in place because of the level of fighting that was going on. So it's certainly a scenario that you want to avoid if you can. And the things that Rex has talked about, and he'll talk about here in a second, are real and they do happen.
Wow, thank you, Jeff. I didn't even realize we'd been involved in one that cost that much. But guardianships, even in ideal situations, take a lot of time. They can take several months to get in place. They cost a lot of money. You're going to pay for at least 2 lawyers, a doctor, typically for the cost of a social study if that's required. There's a lot of going to court. It usually takes multiple hearings with at least 2 lawyers. There's a loss of control. The family doesn't control this process. In my limited experience with guardianship, is that's one thing people despise about it is the lack of control. There's also loss of dignity. Nobody wants to go testify that dad's incompetent or mom's incompetent, and they don't want to be in court while that's happening, but that's one of the things that happens in guardianship. It also creates a major asset protection problem because it opens the door for creditors and predators that is otherwise shut. Now, how do you get to a guardianship? Well, if assets are owned by an individual or we have any form of joint ownership, a home, for example, and one person becomes incapacitated without good planning in place, we have to go to court, typically a probate court, for guardianship of the estate, which is usually the difficult one. The guardianship of the person is usually easier. What happens if you have a trust instead? People can still become incapacitated. But instead of going to court, look what happens. The assets in that trust are managed by the terms of the trust. It replaces the powers of attorney. A trustee has way more authority with an institution than an agent ever will have. It avoids guardianship. It can provide instructions for an incapacitated person's care. You've got a successor trustee who manages it, and they are the ones who use that substitute signature. They provide it. It's easy to manage, easy to change, easy to update, but it works best when all the assets are fully aligned with the trust. So notice that there is nothing about the trust that takes you to court. Now, Connie went through a guardianship in Massachusetts. As I mentioned, she had to get permission from the court there to be transferred to Texas and have the guardianship transferred to Texas. Jack handled most of that, though Carol helped where needed. It was very expensive and time consuming because of the lack of planning. The Texas court requires a bond for an estate that costs thousands of dollars a year. Jack is paying that, but eventually he's going to be repaid. And we've seen situations where family members have to put up tens of thousands of dollars as a bond just to manage the guardianship. The court has to prove any changes for her. So anything that has to do with her care, change of facilities, anything like that, they have to go to court and get permission for it. There's a complete financial accounting every year. Takes some time, costs money, professionals have to get involved. Again, Mike and Carol concluded this is a nightmare they want to avoid. They do not want guardianship. Now, upon death, everything passes through what I like to call the estate settlement cost funnel. There are 4 types of expenses that come out. If you think of these as spigots with a little knob on top, you turn on the spigot and water runs out of there. There's administrative issues. There's 3 of them. I always want to know which administrative rules apply, how many different rules apply, and where do you put your family in this process. Then there is probate expenses, creditor and predator expenses, and taxes. Just make a note that if a Form 706 is necessary, that's the estate tax return, administrative costs are going to increase and it's going to take longer. Now, notice that 3 of those are in red and 1 is in green. Folks, I don't care what kind of planning you do, you're always going to have some administrative expenses. But probate, creditors, and taxes, you can largely plan to avoid those. And a lot of people are able to avoid those. And then whatever's left over, the family gets. Now, it helps if we understand the 4 ways that assets pass. So there's 4 boxes. The very first one we're going to look at is joint with right of survivorship. That's the very first box. So I want you to think of this like your estate, like when you go to the grocery store. They scan every item and they put it in a bag. In this case, there are 4 bags, and they start with the right of survivorship bag. Everything there passes to individual survivors. It seems simple, but you're going to see it really isn't. Then there's the beneficiary designations, or pay on death or transfer on death. These are called contracts. I like to call this planning by the box. I call it that because there's a box where you say, this is where I want assets to go if something happens to me. That's the box. And what you put in that box dictates the rules. What a lot of people put in is individuals. Once you've done that, you're playing by the same rules as you are with right of survivorship. It's not the same getting there, but they're the same once you get there. The problem with both of these, you can lose complete control over the assets, and they blow any tax planning you may have done. Now, if it doesn't pass by beneficiary designation, we ask, is it owned by a trust? If so, it passes according to the terms of the trust. If it is unowned by a trust, there's only one thing left. It's owned by an individual. That means it goes through probate, and it's controlled by will or intestate succession. Intestate succession, by the way, is the will our state legislature has graciously provided just in case you don't do a will, or if for some reason your will fails. Now, if you have a trust-based plan, we use what's called a pour-over will to transfer assets to the trust, so the trust controls distributions. Now we're going to go back to the box. One of the things you can put in the box is the trust. That means the trust actually does control the distribution of those assets. The other thing you can put in the box, and the default in case everything else goes wrong, is the estate. That would be the probate estate. Now, all 4 of these get assets to beneficiaries, but they're not equal in the way they do it. So let's take a look at those administrative rules. You remember I said a while ago, what are the rules and how many of them apply? Well, take a look. Now, with any administration, there's 3 things that you always have to look at. You always have to look at case law, banking regulations, and the Internal Revenue Code and Treasury regulations. Now, joint with right of survivorship and beneficiary designations have one common set of rules. In each state where you have owners, survivors, or beneficiaries, or where assets are located, you have rules that will apply in that state. The Internal Revenue Code has special bad tax rules that apply to those assets. Then in each state, you may have to go through their estates or probate code, the property code, the insurance code, and the family code are all common. There might be others, but those are pretty common. If the assets are owned by a trust, we have one set of rules. The Texas Trust Code if it's a Texas trust, or the state trust code of wherever that trust is located. Then if it's an individual, in each state where we have a real property interest, you have to go through probate, and you look at the probate code and the property code and perhaps other codes. Now, if you take a look at this, you'll realize trust administration is actually simpler than all of these other methods. Now, I didn't say trust administration is simple. It isn't, but it's simpler than all the other options. And we know we do a lot of those. And trust administration, when all other factors are equal, is always faster, cheaper, and works better. One of the things to be aware of is not overusing right of survivorship and beneficiary designations. Some people refer to those as the poor man's will. I refer to them as a poor will. Now, probate. Definition, probate is a technical legal term that means to prove up the will. If you call a law firm and you ask, what does probate cost? They may give you the technical legal answer, but it's not the answer to the question you really want to know the answer to. I prefer the layman's definition. That's the court-supervised transfer of assets for someone who has died. Most people want to know, what's this whole thing going to look like? What people really want to know, and we know because they ask us these questions, how much does probate cost, and how long does it take? Folks, I'm going to give you a hint. If you ask a lawyer that, and they give you an answer, they will lie to you about other things because it's not possible to know. Not if they're being honest. Now, they may give you a qualified answer, but they can't give you a straightforward answer. Here's the reason why. What you should ask is who gets paid first and who controls the process. Now, I'm not going to spend very much time on probate, but I am going to cover those two questions. Under Texas law, the funeral and last illness are the first two things paid, and it's up to $15,000 each if the court approves. There's a family allowance for 1 year if you have qualifying family members. Qualifying family members are typically surviving spouse, minor children, and incapacitated adults. Then there's the cost of administration. Attorneys, court costs, executor fees, preserving safekeeping and managing the estate, and unpaid guardianship fees. Folks, that's the lawyer's favorite part because that's where the lawyer gets paid, or so it appears. However, we have the hospitals and the funeral directors fooled because we don't have to take a probate case until we've been paid. So really, lawyers are first. Secured claims and tax liens. Then, by the way, unpaid child support and interest. I'm about to get to taxes, penalties, and interest. That's referring to those wonderful people at the IRS. Isn't it great that Texas put them 6th on the list instead of 1st? I'm sure you're all cheering. Then comes the cost of confinement if someone was in jail or in prison. Mike and Carol, that's not going to be an issue. Repayment of medical assistance, we're going to say that's not an issue in this case. And then other claims. I'm just going to give you one that comes up sometimes, rental owner issues. If you have any problems getting to probate, we had a very slick renter some years ago who decided not to pay the rent since John Doe died, and he wasn't going to write a check to the estate of John Doe until an executor was appointed. That took 15 months, so he didn't pay rent during that time. They couldn't use the money from the rent to pay things like taxes and insurance and all of that stuff. Well, the renter knew that, and he just took advantage. Now, he set the money aside, When that executor was appointed, he did pay the rent. But he also said, and I still got several months to go on the rent, they couldn't get him out of there, so they didn't go up on the rent for 15 months. They didn't have the money. That's just one of the many types of issues that can come up in probate that people don't think about until it comes up. Now look at that list real carefully and tell me who isn't on that list. It's the family. The people you love the most are not on the list. They're last. They come after all of those claims. Now that tells us the order of payments. One reason to avoid probate is to avoid putting your family last on the list. By the way, it does appear that they may be in there at number 2, though my experience with probate is too often no family allowance is done because there are issues that can come up with whether you can qualify. Now, who controls this process? I wish I could tell you it's the lawyers, but it isn't. It's not the courts, and it's certainly not the family. It's the people on this list who might make claims. The reason nobody can tell you how long this is going to take and what it's going to cost, nobody knows how many claims will come up, how long it will take to resolve those claims, what it will cost to resolve those claims. So that's why you need to ask the right question of a law firm, or you're going to be calling somebody else saying, man, my lawyer lied to me. He told me probate would cost this, and months later, we're still in it. Unfortunately, you may have asked the wrong question and gotten a technically correct answer that didn't tell you what you needed to know.
Hey, Rex, can I jump in real quick?
Yes.
So I want to temper Rex's picture just a bit. I mean, there are obviously a lot of unknowns in the probate process, but if you have a fairly simple probate, we can give you some sense of how long it's going to take and how much it's going to cost. But that's obviously not a given. Things can change. Things can come up that you're not aware of. So I don't want you to come away from this thinking it's a complete unknown situation, but it is definitely something to avoid if you can do it.
Yeah, thank you for clarifying that, Jeff. I didn't mean to make it sound that way. Yeah, firms can frequently give you, this is what we think it's going to be. Obviously, nobody can plan on the unexpected. This is a definition I've actually given to a couple of probate judges of what probate is. It's a lawsuit you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit creditors. My experience is that's not who most people want to protect. Now, think about this for Mike and Carol. Upon the death of either one, the home would be jointly owned between the survivor and the kids of the decedent. It's going to require probate and then a guardianship for the kids that's going to last until the youngest turns 18. And the spouse is going to have limited options. That's not attractive to them. Mike's 401k would go to Carol. She rolls it over, turns it into hers. His kids may never see it. They may be okay with that, but he might want to make sure that his kids get something from it. The life insurance, the kids are beneficiaries and it's going to require guardianship, then the kids get their share at 18. Not a good plan. They're going to have guardianship. The survivor is incapacitated and probate upon the survivor's death. So without planning, they see a lot of going to court in their future. Now, what is a trust? It's a contract that involves 3 parties. The trust maker goes by other names. That's the person who makes up the rules. The trustee is the person who manages the rules, and the beneficiary is the one who benefits. In most cases, the typical living trust, the trust maker serves in all 3 roles. But if they become incapacitated, a successor trustee takes over. They're still the beneficiary. The trustee holds assets for the trust. That's often stated as the trust owns assets. That's beyond the scope of today, but I'll throw it in there. Assets in the trust avoid probate and guardianship. Now, while a person is alive, trusts avoid guardianship for the assets in the trust. They provide instructions for care in case of incapacity, then give you a chance to see how successor trustees do managing the assets. They're easy to manage, easy to change, easy to update. They do work best if you have the assets fully aligned with the trust while you're alive. That means changing beneficiary designations, bank accounts, and that sort of thing. That's what we mean by assets fully aligned. And that's also beyond the scope of today's presentation. After death, assets owned or controlled by the trust avoid probate, distribution instructions for all of the assets. They have faster access to assets. They have faster to, and it's easier to administer a trust. There's fewer complex rules than with right of survivorship, beneficiary designations, and probate. They involve only one state's laws. That is a huge benefit if you have other people in other states. And they provide way more certainty of result than other distribution rules. Now, what could a trust do for Mike and Carol? Well, pass all the assets by trust terms more favorable to everyone, avoid probate in Texas, protect the spouse from existing creditors, future lawsuits, and divorce if the survivor gets remarried. And Mike and Carol are young enough that remarriage is definitely a possibility. Remember, they're remarried. It would avoid guardianship for the children. It's going to provide college education for the kids, something we haven't talked about, but that comes into taking care of the kids. It's going to protect the kids in the future from their existing creditors, future lawsuits, and even divorce in the future. We would do for them what we call a family and money protection plan. It's going to have medical documents for both. So we have Hipaa authorizations, medical powers. We have everything they need to manage if one person can't make decisions for themselves. Plan for the possible incapacity of either one. Provide instructions. Avoid probate, guardianship for the kids. One vehicle to transfer all the assets. The kids are going to get a college education up through a bachelor's. Now they can plan further than that, some do, but that's what Mike and Carol wanted to do. Now they have some joint charitable. They want to give $10,000 to Big Church in Frisco, the church they go to. Then Carol wants to give $10,000 to Mothers Against Drunk Driving because her parents were killed or severely injured by a drunk driver. Their community property, they want to give 1/7 to each child and 1/7 to Alice. Alice is really part of the family. The survivor gets the house in exchange for other assets. The B share is going to protect the survivor and the decedent's children in case of remarriage, enough to get the kids started in life. They're separate property. There's going to be some benefits going to the surviving spouse while they're alive. Some goes into trust for the decedent's kids. It all ultimately goes to the decedent's kids. That's where Mike and Carol are right now. Now we're going to part 2, 21 years later. Now we can't go 21 years into the future, so what we're going to do is take Mike and Carol and say that planning was done 21 years ago. Mike is now 65, Carol is 64. The kids are 38, 36, 35, 33, 32, and 30. We're going to take you chronologically since the first plan we were talking about one slide ago. Carol's mom died 19 years ago. It took 3 years to get everything through the various probates. Probate was more expensive than expected. She inherited a condo in Colorado, 2 rental properties in Texas, and some money. Paul Brady passed 7 years ago from cancer when Cindy was in college. Paul Brady and his wife had good estate planning that made the estate settlement fairly simple. Mike helped his mom, Grammy, sell the ranch and move her to an assisted living facility close to them, and they get to see her on a regular basis, and the kids go and visit, and her situation's pretty nice for the last few years of her life. When she became incapacitated, there were instructions for her care, and it was fairly simple. And then she died 5 years ago. Now, Paul had asked Mike to pass any leftover ranch proceeds to divide it by 9 on Mike's death. They wanted each of the boys to get 2 nights and each of the girls to get 1 night. That's how much they came to love Carol's girls. They treated them in some ways like their own blood grandkids. Now, that raises an interesting question. How are the boys going to feel about part of the ranch or the ranch proceeds going to the girls. It's been in their family since their great-grandfather. I'm not going to try to resolve that today, but just that can be an issue and a source of conflict. The oil and gas revenue went straight to the boys, or will go straight to the boys on Mike's death. The oil company stock ultimately goes to the boys, but Carol can benefit while she's alive, so it can be used to take care of her. Sam retired, and he and Alice moved away 5 years ago. And end of the story for them here. They're friends, but Alice is no longer part of the family. They're not giving anything to Alice in this updated plan. Carol bought a real estate business 16 years ago, partially with inherited money and partially with community money. That is surprisingly common, and it's going to create some weird issues, as you're going to see. Mike is now retiring as a senior partner. He's in stage 3 of multiple myeloma, and it's causing them to readdress their plans. He's been told he's likely to be in a wheelchair in 1 to 2 years, and he has a 4 to 6 year life expectancy. Of course, nobody knows for sure, but Mike and Carol are trying to plan accordingly. So Carol put her company up for sale so she and Mike can travel and do things while he's still able to. And they're preparing for Mike's incapacity. They sold the home and they bought a single-story home and downsized. Now let's look at the kids. Greg, his wife Nora is a nurse. They have a son, Kevin, and Mike and Carol love Nora. She's a great addition to the family. But they are concerned if something happened to Nora, that Greg might fall for a gold digger. He's quite the ladies' man. Women have always adored him since high school. And they think he got really lucky with Nora. Some of his girlfriends weren't so good. He's an obstetrician. He's done very well financially. They don't need Nora's income anymore, so she quit nursing to go into a catering business with other family members. They own a beach house. They've let everyone in the family use it at no cost. They don't charge them rent. Hey, just go down there, take a week. And everybody in the family appreciates Greg and Nora's generosity. He refers to the girls as his sisters, and he feels close to all of his siblings, and he looks out for all of them. Peter served in the Air Force as an officer. That changed him and gave him direction after his days in the service. He's got a business degree. He's good with money. He has a broken engagement. He's single. Now, Greg's introduced him to several women, but none of them have worked out yet. He's in business with little brother Bobby. Bobby's become incapacitated, as we're going to see. Peter is happy to help out his injured little brother. It gives him a chance to be a big brother and help a brother. And he remembers Greg paying for him to fly home for Christmas one year when he was on leave from the Air Force. So he's really close to his brothers. He sees the girls as stepsisters. He's closest to Jan of the girls. Now, he doesn't have a bad relationship with them, but he doesn't really see them as blood sisters. Bobby became a race car driver. A crash left him significantly disabled. He was paralyzed, but he's gone through rehab. He is improving. Greg, by the way, made sure that he got the best medical care available. He went back and got his business degree at 28. Mike and Carol paid for that. He's good with money, but he's unable to make as much because of his physical limitations. He's married to Tracy. Mike and Carol love Tracy. Now, Peter likes Tracy, but he doesn't want to be in business with her if something happens to Bobby. Trust me, there's a lot of people who have a business partner who they don't want to be in business with their partner's wife. He sees the girls as stepsisters. He's closest to Cindy and then Jan, who Jan kind of played like a second mother to him. Tracy is going into business with Nora, Marcia, and Wally. Marcia is a college grad. She became a fashion designer. She married Wally Logan. He's a likable, fun-loving toy salesman, but he's often out of work. Marcia developed an alcohol problem. She's kind of gotten past that. She hadn't had a drink in 3 years. She stays at home with their 2 kids. She's still popular and outgoing. but she isn't a real good decision maker. She's not a very good money manager, and unfortunately, neither is Wally. Mike and Carol have helped them financially in the past. They're close to Greg, and they really like Nora. And she sees Peter and Bobby as stepbrothers. She does like Bobby's wife, Tracy, and she's going into business with Nora and Tracy. Jan married Philip Covington, one of her science professors in college. Then she became an architect at the Phillips firm. They cannot conceive of children, or can't conceive children, so they adopted a Korean girl named Patty. She's still jealous of Marcia's popularity and personality, but she's passed Marcia in a lot of ways. She's a good decision maker, she's good with money, as is her husband. Now that Mike's retiring, she might even be up for junior partner. She's closest to Peter and Bobby, and she looks up to Greg, but she's not as close to him. She sees the boys as her brothers. Now, one of the issues Mike and Carol see is that if Marcia sees the boys one way, Jan is likely to see them another way just because she doesn't agree with Marcia. Mike and Carol like Philip. He's been good for Jan. Cindy is a mass communications major. She's a college grad. She's become a radio DJ. She married her boss, Ken Michaelman, a Jewish widower, more than 15 years her senior. She married him 2 years ago. His wife had only been dead about a year. They didn't have an affair or anything, so we're not adding that to the mix. She has 2 stepchildren. One of the issues is she's 10 years older than the oldest one. That can create some issues within her family, and Mike and Carol are a little concerned about that. The children were 18 and 16 when they married, so she didn't really raise those kids. Ken is good with money. He's very conservative. He kind of overshadows Cindy, but he's been good to her, and Mike and Carol like Ken. They see risks between the sets of kids and between the girls. The firm insurance should cover Mike's medical, so they're not worried about that. They're concerned that the girls might not understand Mike's business being his separate, since they didn't know he was a partner before he and Carol married. They're hoping for the best with this business venture, but they have concerns about Mike, Marcia, and Wally. They're concerned that a failure could create a huge rift in the family. 3 of their 6 kids are involved in this, and they don't want to see it blow up. Greg loaned Peter and Bobby money interest-free for their current business venture, and they paid it back. But Greg has told them privately he's concerned Marcia and Wally won't pay him back. But she's still his sister, he loves her, and Greg is the type that if he doesn't get it back, he'll go on and not make a big deal out of it. But it could create problems with Nora and Tracy. The boys might not understand why Paul and Grammy wanted to give the girls any proceeds from the ranch. Marcia and Cindy have mentioned they think Carol's real estate business should be her separate property, since Mike's business is his separate property. They don't understand that community property helped pay for that. But the boys care whether it's community property, and I'll just be real blunt. In the typical situation, the boys are going to want Carol's business to be all community. The girls are going to want it to be all separate. So these issues will go beyond Mike and Carol. It'll even get down to the kids if Mike and Carol don't plan properly. The girl's father has been back in the picture for the last 6 years. The last 4 years, he and his wife have taken both sets of their kids and their families on a vacation. All together, they pay for everything. It's very attractive to go on a vacation when it's paid for. Well, he has 2 stepchildren, the girls know, and they seem to like him. They're likely going to inherit from him, but they have no idea how much. Marcia appreciates Greg. She thinks Jan believes they are in competition. She sees Cindy as the baby of the family. She thinks Peter and Bobby benefited from a lot of something other than their own hard work and good choices. She thinks they just got lucky, and she thinks that somebody other than Greg helped them. She doesn't understand why Wally hasn't been as successful as the boys. He's a lot of fun, even if he's a little quirky. She might feel like the family failure. She might resent how the others are doing. Bob and Pat, Mike and Carol have a home, a brokerage account, checkings and savings, household goods, 401k and IRA for Mike, with Carol as the primary beneficiary. 401k and IRA, Carol owns it, Mike is the primary, 2 cars, life insurance on both, the trust owns it, and the trust is the beneficiary. Then from pre-marriage, they have the IRAs. This is Mike's part. The boys are the primary on that. His architectural, he's got a 10% interest. And then the oil company stock from Paul and Grammy are inherited, and the oil and gas royalty from Judge Brady is inherited. He also got Paul Grady's gun collection. Carol has her IRA that the girls are the beneficiaries of. She inherited 2 residential rentals. Mike did a lot of free work on them. That comes into play. Brokerage account, she inherited from her parents, and the Colorado condo. She also has a China doll collection that she inherited from her mother. And Cindy, the doll lover, currently has it. Now, I threw this in here because it shows how one little bitty thing can create a problem within the family. Carol told Jan and Marcia that Cindy is holding it since they didn't have room for it after downsizing. Cindy told Jan and Marcia that Carol gave it to her. So Marcia and Cindy have not told Jan and Marcia the same thing, and that can create problems on down the road. I've actually had something like that come up in a case. That's why I put it in there. Medical decisions, Mike and Carol are going to have each other as the first decision maker. And then Greg, he's a doctor. He knows more about medicine than anybody else in the family. Then Nora, she's also got medical training and they adore her. Then Jan's a good decision maker. Then Peter, but they didn't put anyone else on there. That could create some issues with the kids, especially Marcia maybe feeling left out, and perhaps Cindy. Bobby's likely to understand why he wasn't included. They just don't feel like they should add that burden to his life. For charities, well, Carol now wants to give $50,000 to MAD. Mike wants to give $50,000 to cancer research, and they want to give $100,000 to Big Church in Frisco, which they're still going to. So we're going to map out a plan for community property, Mike's separate property, and Carol's separate property. You always have to do this in blended family. They want to take care of each other while each is alive. They want to do an AB plan. I'll show you how that works. The survivor benefits from both the A side and the B side. The B share goes to the first decedent's beneficiaries when the survivor dies. That prevents disinheriting any children. It reduces friction in case the survivor got remarried. And the B share is not part of the survivor's taxable estate. It removes the B share growth from the survivor's taxable estate, and it avoids capital gains taxes on both deaths. Now, those last 3 are not really going to be part of our presentation, but just know they're out there. When one dies, separate assets are going to be for multiple purposes. First, the AB, here's how it works. The A side stands for the surviving spouse, or A actually stands for the above ground spouse. The survivor controls it, they can give it to anyone. And it includes the survivor's separate property, the survivor's share of community property, and it can even pick up unused exemption and overage from the unused B portion, provided they file the Form 706. Not really going to talk about that today, but it's at least an option. The B side, and the B, if you haven't guessed, stands for the below ground spouse. It's the deceased spouse's share. And we know you can't take it with you, but the beneficiaries of that share are the surviving spouse and the kids. The decedent's kids receive it when the survivor dies. It uses all or part of the decedent's exemption, and what goes in that B trust is asset protected. That allows us to use 2 estate tax exemptions instead of 1. So that's in a nutshell, how an AB plan works. The community property is the simplest part of this to plan. They want to divide it equally between all 6 children. Very common in second marriages to divide community property that way. Though sometimes they might divide it half to his and half to hers. Just so happens they both have 3. Mike's separate property while Carol is alive. She's going to receive income, principal for health, education, and maintenance. Benefits in, though, if she remarries. After she passes, 1/9 of the oil stock goes to the girls in trust, 2/9 goes to each boy. Everything else goes to, I'm sorry, that should read, oh, it does read the boys in trust. Mike's separate property too, when Mike dies, it goes to the boys immediately in trust. So there's 2 different parts to Mike's separate property. We're going to map out both. Carol's separate property, while Mike is alive, part of it, he's going to receive the income while he's alive, principal for his health and maintenance. Benefits in, though, if he remarries. And after he passes, everything goes to the girls immediately in trust. Carol's separate property, when she dies, separate property too, all goes to the girls immediately in trust. So we kind of put this in here so you get to see the different aspects of planning that are going to go on. Now, predator dragons. Here's the definition of asset protection. It's protecting and preserving assets from unnecessary loss. The biggest risk to your estate plan is your child's spouse's divorce lawyer. Beneficiaries' debts can be a problem, and we can be talking about extraordinary bills, especially medical bills. Predator threats like future lawsuits. And trust me, anybody can be sued, and anybody with money is a target. The question is, does a beneficiary have a higher lawsuit risk job? We always want to ask that of the beneficiaries. And what state does the beneficiary live in? Because not every state treats assets the same way. Texas is a very good state for asset protection planning. How would the loss of those inherited assets affect the beneficiaries? Well, if one of those dragons comes flying out of there, you need a plan to fight him off. So Bob and Pat have learned there's really 3 ways they can pass assets. Outright, that provides no protection for the beneficiaries. If they get sued, if they go through guardianship or probate, they're subject to all of that. Then there is what we call a convenience trust. It provides some limited protection. It'll keep the assets separate properties so they don't become commingled. Still subject to, well, it can't avoid probate and guardianship, but it's still subject to a kid's bad money management, the IRS on estate tax, and creditors. Then there is what we call a heritage trust. That's our terminology for it, and it's a trust that provides creditor and lawsuit protection, bad marriage protection, first death in marriage, i.e. bloodline protection, can even keep beneficiaries from losing government benefits if they would otherwise qualify for government benefits. Bobby might be a potential candidate for that. It goes into a dynasty trust. It's not subject to estate tax, perhaps for hundreds of years, maybe forever. Now, those are the 3 plans that are available to Bob and Pat. They chose the Heritage Trust, and here's one reason why. Carrie was a young lady who inherited $3 million from her parents. She inherited it in what we call a convenience trust. She was in a car accident. Somebody tried to go around her at an intersection, clipped her bumper, caused her to veer off. She T-boned a van load of daycare kids, killed a driver and 2 kids. There was a huge lawsuit over that case. They sued the guy who hit her, and they sued Carrie. The jury came back with a $9.8 million judgment. They found the guy who hit Carrie 90% liable. They found Carrie 10% liable. Now, I have no idea. That's a real case. I don't know why they found her liable, but they did. The case took place in Colorado. Under Colorado law, if you're 10% liable, you can pay 100% of the claim. Carrie lost her entire $3 million inheritance because of that lawsuit. Now, If you're in California and you heard about the accident, you could pay for 100% of it. Okay, I'm kidding about that. Now, here's the reason that Mike and Carol, they didn't want what happened to Carrie to happen to their kids, and they considered the story of Ted. Ted got a little bit too much elbow exercise one night. He failed to negotiate the bridge over the Chappaquiddick River, and Mary Jo Kopechne died. This happened in 1969. The Kopechne family was going to go after Ted Kennedy. He was worth millions, but his parents had left him a heritage trust. The only thing they could get to was his car insurance. So Carrie was 10% liable. She lost everything. Ted was 100% liable, and he lost nothing. That's what a heritage trust can do for your kids. Not that we encourage them to go drunk drive, but that's reality, and that's the world we live in. So I'm going to wrap this up. When you're designing your plan, you need to analyze your family situation, your financial situation, and you need to determine what your goals and objectives are. You need to analyze specific estate planning tools considering your family situation, your financial situation, and your goals and objectives. A lot of the planning we see does not meet people's goals and objectives. Sometimes they haven't even clearly defined those goals and objectives. Also consider, what are you trying to protect? Who are you trying to protect it from? And what tools are actually going to do that? Every single case is different. Now, before planning, you've got your money in your hand, and your entire estate is at risk. The dragons are going to come. We can't tell you which dragon is going to come along and grab the money, but folks, you're at risk for it. What planning does is we have the person, we build a castle around them so that they're protected by the castle. That isn't going to keep the dragons from coming, but they've got to get through the castle, and you have a knight who loves to slay dragons out there with the planning we've talked about today. So that ends our presentation about Mike and Carol. I hope you have enjoyed it and hopefully learned a lot. I'm Rex Hogue. I'm now prepared to answer questions.
Wow, that was incredible. That was very, very good. Hey, does anybody have any questions? Well, there you go.
Do we have them take the test?
Yeah. let's give them the test. If you don't have any questions, and I know that's a lot of information, and we will get the recording out to y'all. It'll take about a week till we get the recording up and into YouTube. We'll send that out to y'all. I have posted a couple of times the link to the slides in the chat. Someone does have a question there. Oh, I guess Jeff has answered it in the chat. But again, for the CEUs, we'll be sending out a follow-up email here shortly that will have the information for the CEUs in it. You're going to have to fill out the form and the sign-in sheet and return them to Sheila. You can either scan them and email them, or you can actually take a picture on your phone and email them. Either one of those works. And yes, Daisy, the recording will go out to everyone. It will actually go out to everyone who even registered for the event. I think we've got, and nobody, Jeff's been answering the questions. Here we go. Jeff, I'm going to let you handle this question.
Okay. So the question is, my husband just died without a will. I have 2 stepdaughters and 1 mutual daughter. What happens to the house I live in currently? It is paid off. I'm not wanting to move anytime soon. So we're going to assume with this question that it is a community property. And in that scenario, it goes back to what Rex was talking about. Half of that property you own, half of the property your husband owned, if you're in Texas, and you continue to own your half of the property, but his half of the property is going to be split between you potentially. I'm sorry, but it's going to be split with the daughter. So you're going to end up being joint owners in that house. Now it's not sure, there could be other factors at play here, but that's what I see. Rex, do you have an additional thought?
Assuming it's the husband's daughter, if he dies first, I think that's exactly right, absent planning.
Very good. Very, very good. Anybody else? I want to make sure we
Hey, Marty, one other thing that
go right
I'll
ahead.
add to Ann's question, and that is that the surviving spouse, regardless of whether it's community or separate property, the surviving spouse maintains what's called a homestead interest. So even if the surviving spouse doesn't own any part of the house, the surviving spouse has the right to continue to live in that house for as long as they want, pursuant to their homestead interest. Now, there are certain obligations. The homestead spouse has to pay certain portions of the mortgage if there is one. I know here there isn't one. There is an obligation to pay taxes. So there are some obligations to having that homestead right, but be comforted in the fact that if you're a surviving spouse, even if it is your spouse's separate property, you have the right to continue to live there until you abandon that right.
The next question, Ann says, what do I need to have them sign off on their parts?
Well, that's a little bit more detailed than we probably have time to get into here, but I will say that there is always the ability to reach agreements with those that have interests. And if you can reach agreement, there are certain documents like deeds that you would end up signing off on to transfer those interests. And we always recommend that you consider doing what we call a family settlement agreement that goes along with that. So not only are you transferring interest in property, but you're also including a document that includes releases between the parties so that you don't have to worry about the parties suing each other down the road if they get buyer's remorse for some reason.
If you have a will, can you make a trust plan too?
All right, Rex, that's you.
Absolutely. We, in every trust plan, we also do what's called a pour over will. And we didn't get into the documents, but yes, you can have a will and a trust, and all of the documents we've talked about today are part of a planning package.
Very good. Outstanding, y'all. It was very, very good. Well, thank y'all. Oh, there you go. You got a big one. Could I get you to advance the slide one more time so we give people the information on next month's, there you go. Here's the information on next month's webinar where we're addressing the next question.
To build on the previous question, what happens if the father passed away 5+ years ago with no will? What happens if the wife, who's the mom, dies and sets up a trust? If she passes with no will, does that mean her portion of the home goes to the kids, making the kids joint owners of the home, opening it up to all the dragons?
Rex, I'll let you take that one.
Yes, if I understood the complete question, Dad died several years ago. I didn't get whether he had a will that gave everything to Mom.
No, he had no will.
No will. So the first question I have is we may have to go back and do some form of probate to get it to her. And then you may have a trust administration for her and still that probate for him that's going to dictate what happens to the rest of it. Again, we left you that 1-800-YOU-BLEW-IT number. It's going to be a mess. So when someone dies, it's important that you get the administration done, because it's really difficult when the second one dies before the first one's administration is complete. And Jeff may have more to add to that. I don't know. Okay.
Go ahead.
Yes, and it is recorded, and Marty will send out the recording in the next few days.
There is a question over in the Q&A, and now we're coming into a few of them here. Marilyn, the CEU forms will be sent out in the follow-up email. They're not here yet.
This is from Daisy. A half-sibling, obviously blended family, has 1/7 of an estate that someone else paid the cost of the house. All other siblings signed over their interest. What can be done?
I'm not sure who they signed their interest over to. Was it that one or the surviving spouse?
That's probably going to require some legal advice from somebody on a one-to-one basis with more information, I think.
Yes. There's a wide range of answers. More specific question, if you could, please.
Depending on the circumstances. Yeah.
They signed it over to the one. Or I don't. That doesn't.
Yeah.
I'm not understanding that yet.
Yeah, Daisy, I think you're gonna need to get with somebody one-on-one, and because they're gonna have a lot of questions for you in order to be able to home in on an answer, I think, in your situation. But again, when we get into one-on-one legal advice, that really requires an appointment with an attorney. Can both in one plan? Tiffany has a question in the Q&A. Can both in one plan? Maybe this is a follow-up.
I think I understand this. Typically, for married couples, we do one plan that covers all aspects of it. Like the example we gave here, Mike and Carol have a plan, but it covers his, hers, and their stuff. So it depends on the situation, but most married couples in Texas anyway would do a joint plan.
Terry has a question. Once a trust has been created, can the beneficiary percentages be adjusted later?
Absolutely. Typically, the kind of trusts we're talking about are revocable living trusts, and that means you can change them as long as you are mentally capable of doing that.
So Marcia has a question. What is the best way to locate a will that has not been probated yet? We have stepchildren trying to locate it, but no success yet. Are there research tools?
Boy, that can actually get down to where the person whose will it is put it. One personal experience I have is one of my grandfathers. He had taken it out of the place where he kept it, and he put it in a box of junk for reasons that we never could understand. It took several months to find it. Everybody knew it was there. They tore the house apart before they finally found it, and no idea it would have been in that particular box. Obviously, nobody thought to look there for several months. So that's about all I can tell you is, it's possible that they might have it in a safe deposit box if they have such a box. Occasionally, lawyers might have kept the original. I think lawyers have by and large gotten away from doing that because it creates all kinds of issues. Not to mention, if something happens to the lawyers, where do those wills go? It might also be possible to check with the local probate court or the county and see if it's been filed. But normally, you're just going to have to figure out where that person put it.
I guess letting someone know where your will is probably
Great idea.
yeah, a good advice as well. Well, once again, thank you so very much. We appreciate it greatly. We appreciate y'all joining us today. Great information, great presentation. We look forward to seeing y'all next month for addiction in the family and how it affects care and planning. And please look out for our follow-up email that you should get here in a couple hours. Thank you so much, and y'all have a great day.
Thank you, Marty.
Thank you.